Also with us, we have your counsel, Mr. Grimurthy. We have, on behalf of the prosecutor's office, is it Mr. Frezza? We also have the MDOC here in the form of Mr. Haven. And I believe I see Judge Burmeister there as well, who is the victim in this case. Also, it appears that we are recording this matter by video conference today. My understanding is there's an agreement between the parties to allow this matter to be heard by video conference. Is that correct, Mr. Grimurthy?
That is correct, Judge.
All right, and for the people, that's correct as well?
It is, Your Honor. And for the record, Mike Frezza, Assistant Attorney General on behalf of the people.
All right, Mr. Frezza, thank you for your identification. Mr. Talbot, I know you can't see this in detail, but I'm holding up a copy of the pre-sentence report in my hands. It has my notes on it, but you've had a chance to review this report with your attorney, Mr. Grimurthy. Is that right?
I believe we did.
All right. Mr. Grimurthy, are there any changes that you wish to propose to the body of the document or any challenges to the scoring?
No, Your Honor.
All right. Let me go to the people. Mr. Frezza, do the people have any changes they wish to propose to the body of the document or any challenges to the scoring?
We do not have any changes to the body of the PSR or any changing to the scoring.
And I understand there's a victim that wishes to speak. Is that correct?
There are two victims on Zoom, Your Honor, Judge Burmeister and Magistrate Hill.
All right, let's go ahead and collect the testimony of the victims. Judge Burmeister, I'd like to start with you, please. If you would please state your name, put it in the record, and then I'm very interested in what you have to say, sir.
I am Monty Burmeister. I'm the probate judge in Crawford County.
All right,
And
please proceed.
and certainly, thank you. Ms. Hill can correct me if she needs to. I spoke with her this afternoon, and I believe she's not going to make a statement, but wanted to watch the sentencing. For my part, I would like to start out by sharing with you where I was at when I learned of the threat and the conduct that Mr. Talbot engaged in. I was in Detroit at a meeting. The meeting's not important, but it related to judicial business. And I got contacted from my court administrator, and she described the nature of the threatening conduct and who did it. And as we were talking, I said, well, he's in custody, right? And she said, no, he's not. And that led to a series of questions about why he had not been arrested when he had been involved with two police officers at the time that he was wielding the machete. That was a matter to deal with later on, but the point of me telling you that I was in Detroit was I had to call my wife, who was at home, and tell her about the threat. And I had to send a picture of Mr. Talbot to her. And I know you're familiar with Grayling. It's a small town. People know where I live. I mean, it's not a secret. So I was 3 hours away from my wife. And when I gave her the information, I said, remember, this is where the guns are. They're loaded. If you see this guy come in the driveway, first get the gun, then call the police, and be prepared to kill this guy. Now, my wife is a social worker, and she has spent her entire career doing maternal infant support, basically fostering new babies. So I'm telling her, as somebody who cares about life, to be prepared to take one. Now, I recognize that she's not the victim here, but that caused me mental anguish to have to do that. After I had that conversation with her, I talked with my youngest son, who was visiting from out of state in college. Young 20-something. And so a kid that ought to be thinking about homework and girls and social scene, I'm giving him the same instruction. If you see this guy, get a gun, call the police, if he comes in a threatening manner, kill him. Now, my 20-something shouldn't have to do that. Next, I talked with my older son, who lived very close to me. Told him the same story, gave him the same instruction. His comment to me was, "Dad, why didn't they arrest this guy?" I said, "I don't know." So I think about this, and I think about the other people involved, and this is when he does something like this, it's kind of like a set of dominoes going. I'm not going to get into great detail about what we do because I don't want to compromise security protocols. But my court administrator has to deal with this. As soon as the threat's made, she makes sure I know, she makes sure the referee knows, she makes sure staff knows, she makes sure friendly court staff knows. So it's stress on her, it's stress on my staff, it's stress on the referee. Ms. Hill did not give me authority to comment for her in terms of her general thoughts, so I won't do that. But I will say, Judge Elsenheimer, that Referee Hill also had to make adjustments at her house because of the nature of the threat. Now, as we're talking about this, a couple days ago, somebody made threats to the Cadillac City Council where they had to cancel the meeting. And so what's happening there? These people that are duly elected officials can't proceed with the business of government because people are threatening their lives. Now, why is that happening? In one part, I say, well, it's happening because people think they can do that and there's no consequence. Or they think they can do that and they know there's a consequence, but they're okay with the consequence. They think they can live with it. It's not that bad. It's kind of like the guy I once put in jail for contempt for 10 days. He said, "How much time did you say?" And I said, 10 days. He said, "Oh, I can do that standing on my head." That's the only analogy I could give, is that if they recognize the consequence, it's something they're willing to bear. I looked at a bunch of sentences and a bunch of events in Michigan, and I'm not asking you to do this, but if you looked it up, there's a ton of threats against public officials, and there's a number of cases against threats against judges. And what I would say to you is that I am hopeful that you give a sentence that emphasizes deterrence and punishment, because this happens a lot. And the general comment I would make to you and would ask you to consider, Judge Elsenheimer, is there's a lot of people paying the price for Mr. Talbot's criminal conduct. My administrator is, my staff are. When my staff walk out in the parking lot and look to make sure there's nobody with a machete walking around in the parking lot, that's a price that's being paid for this conduct. When I have to tell my wife to be prepared to shoot somebody, that's a price. When my administrator has to be stressed because of dealing with the threat, that's a price. When Ms. Hill has to make other or take precautions at her home, that's a price. And what I am asking you to do is recognize that a lot of people are paying a price for his conduct. And he needs to pay a price for his conduct. And the price ought to be a sentence that is very, very clearly a deterrent to him and to others that think they want to do this, and is a punishment, because a sentence is meant to be a punishment. And no matter what you do, and I appreciate, Mr. Havens has made a recommendation, and I know you're going to do whatever you think is best. But no matter what you do, at the end of the day, that cost, that price is going to continue, because it's not as though I unload my guns and put them in a lockbox. I don't, because I take the threat seriously. So he has done something that he probably never is fully going to pay the price for. But I hope that we have a sentence that instills upon him and others who decide to act and think like him that you can't do this. You cannot do this. What is the point of it other than to disrupt the work that we are supposed to be doing? As I look, I don't know anything really about the hearing that he was in. I understood later on that frankly it was kind of benign. I don't know what was going on. But there's no way he should come out unscathed, walking around with a machete with an illegal intent. And what's even more maddening, which is an issue for me, I suppose, at a later point, but is the two law enforcement officers dealt with him, didn't recognize that they should have arrested him, and thought, at least one of them thought that because it was an open carry state, that it was okay that he was walking around with a weapon stating an illegal intent. When I heard all of this, I called a colleague and I said, okay, here are the facts as I understand them. Am I missing something? And they said, no, you're not missing something. He's committed a felony. So, the other thing I would say is I understand, I was told the rec earlier from the clerk, I think you should have, whatever jail you do, if you do jail, I think you should have a probationary term. I think he should have a tail. And if he's not going to have that, then I think he ought to serve the maximum. Now, I didn't ask for the maximum initially, and I really, frankly, am not today. I think he should have a year in the county jail. But I recognize the rec is something less than that and no probation. And what I would say to you respectfully is, why should a guy that did what he did and made the threats he did against two judicial officers, why should he have no probation? Why shouldn't he have eyes on him? Why shouldn't he have to report? I mean, I don't know if it comes through on my voice in Zoom, but to say that I am fed up and tired of guys like this thinking that they can do this kind of thing and get away with it, that would be an understatement. And I respectfully hope that you sentence him consistent with what I've requested, and that you think about the price that all the rest of us are paying and recognize that he needs to pay a price that's commensurate with his conduct. Thank you for the opportunity to address the court.
Thank you, Judge Burmeister. We're very sorry for what happened to you and your family. Is there another victim that wishes to speak at this time? Mr. Frezza?
Judge, this is Teresa Hill, and I was the referee that presided over that hearing that precipitated these events. And I did indicate to Judge Burmeister earlier today that I did want to attend today because obviously these proceedings are significant to me. And I will go ahead and explain the reason why I had some reluctance to speaking today, but I am going to say a few words. But I think the reluctance on my part, and I had actually, thought about putting something in writing and providing that in advance. It is difficult to acknowledge the fear that behavior causes and the ripple effect that causes and the impact on not just myself, but my family and my neighbors and my coworkers. because doing so on some level, it feels as though it's almost, giving into or, it was designed to harm us, and that is an acknowledgement that in fact Mr. Talbot succeeded in that. In addition to that, unfortunately, as even a referee, and I don't think that we are subjected, generally speaking, to the maybe the level or the amount of threats that the judges are, but it is become somewhat part and parcel. I don't feel like it is that uncommon for us to be at the end of threatening behavior of this nature or similar natures. So with regard to the hearing that day, it was a show cause hearing regarding child support. I know that I treated Mr. Talbot with respect, not that there would be an excuse for his behavior regardless of that. What I also find to be interesting is his conduct during that hearing, I think actually, could have warranted a recommended finding of contempt because of the disrespect that was being given and the indication that he did not intend to comply with a court's order willfully, not because he could not. Rather than making the recommended finding of contempt at that point, I chose to give Mr. Talbot an opportunity to do what he needed to do to be in compliance and adjourn the hearing out to a later date. So we continued with our hearings. We had a full docket, and at some point law enforcement came in. When law enforcement comes in a certain way that something has gone awry. So they came in, asked me to step off the bench, advised me of the threatening behavior. At that point, everyone that's in the courtroom to do business is also impacted because they're aware that there is a concern, and it's pretty apparent that it's security related. Obviously, all of the court staff then is on heightened alert of what is going on. So it certainly continued to have an impact on, the rest of the proceedings that day. And then similar to Judge Burmeister, then I have to then have a series of communications with my loved ones to let them know, be particular. I mean, we always unfortunately have to be vigilant, but be particularly vigilant and be ready. And then it has to even go so far as my neighbors. I'm sorry you live next to a referee, but now I have to tell you, please, if you do see something unusual or you do see someone milling about my house, don't approach that person. Make sure that you protect yourselves. So Mr. Talbot's conduct, as I said, unfortunately, it seems to be all the more common, but it does have a very real day in and day out impact on everyone who works within this court system and is just doing our best to do our jobs and to treat people, Mr. Talbot and everyone who is coming here to do business. I mean, we are here to serve the public and to treat them with dignity, and it's unfortunate that someone would believe that they are entitled to act in a way that is threatening and terrorizing to us and to the people that we care about. So thank you for the opportunity to speak.
All right. Thank you, Referee Hill. And again, as with Judge Burmeister, I'm so sorry for what happened to you in this instance.
If I may, Your Honor.
Mr. Frezza, are there any additional victims that wish to speak in this matter?
There are not, but after we've concluded the victim impact statements, having heard the description of the effect, the psychological effect on both victims, speaking of anguish, speaking and describing anxiety, describing fear, even though it doesn't change the guidelines, I would amend my previous statement and say that OV4, psychological injury to the victim, I think these items may require psychological treatment. It doesn't require psychological treatment. I'm not going to inquire whether they have. I think that that is unnecessary given the OV. Should be scored 10 points. That being said, it doesn't change the 0 to 9 of the guidelines, but I think for accuracy of the record and the integrity of these proceedings, OV4 should be scored at 10 points, Your Honor.
All right, Mr. Gurmurthy, if you'd respond to the request to amend the sentencing information report and the scoring of OV4, please.
Just based on the statements I've heard from the victims in this matter, I would have to concede and agree with Mr. Freza's comments that OV4 should then be scored at 10 points.
Based on the court's review of the proposal to amend OV4, my review of the statements that were made by Judge Burmeister and Referee Hill, it's clear to me that the behavior of the defendant did result in the kind of psychological trauma that could in fact require professional treatment. Whether or not that treatment has been sought is not conclusive. I agree with the parties. OV4 should be changed to 10 points on rescoring that. That does increase our total OV to 40 points, which as I understand does not increase our OV level. Is that correct, Mr. Frezza?
It does not change the grid from, I believe it's B3, Your Honor.
Mr. Gurmurthy, you agree with the math?
I do. I agree. I'm reviewing it, and I agree with Mr. Freza and the court.
All right. Let me go back to Mr. Frezza. Mr. Frezza, do you have any argument regarding sentence in this case?
I do, Your Honor. I will offer observation consistent with what Judge Burmeister has said concerning the rise or uptick in threats against judicial and other public officers. I personally have handled a number of those cases, and for one reason or another, they seem to be on the rise. The Michigan Department of Attorney General prosecutes these cases, and I'm not the only prosecutor who has experienced in their personal docket an increase in the number of these threats to judicial officers and to other public officials. This defendant appears to exhibit, based upon what I see in the PSR and the police reports and the victim statements, a tendency to remain non-compliant with both law enforcement and the judicial system. We heard Referee Hill say that he appeared not unable to comply with the court's order, but rather unwilling to. And the date of the incident, Your Honor, he was upset with the hearing, and his remedy, rather than working through a lawyer, was to grab a machete, which, if my memory serves me correctly, was 11 or 12 inches, and go and threaten the judicial officers. He was approached by police, the Michigan State Police, and paid no mind to them. Didn't feel like he needed to even answer their questions concerning what he was doing with a large, dangerous weapon. I'm concerned that if that is his state of mind, that he's non-cooperative, which apparently happened with the MDOC agent that was creating the pre-sentence report, that it's noted that he was non-cooperative with the agent, that behavior, unless there is some stark consequence, will continue. Even the therapist that reviewed him says he has difficulty regulating his emotions. In his mind, there's going to be a next time. And in his mind, I would suggest to the court that there has to be some strong memory that's going to interrupt that impulse, make him control himself when he dislikes what's happening in the world. And we all know that everybody has frustrations. Things don't always go exactly as you like them to go. But if the remedy is to resort to violence, particularly, Your Honor, violence against public institutions and public officials, then I think generally the society is heading down the wrong path. We in the criminal justice system rely on judges to make orders, and most of those orders almost all of them have to be voluntarily complied with. Well, if what a judge says or a referee says no longer can be abided by voluntarily, then it is a degradation, a fatal one, of our judicial system. And that cuts to the rule of law on which this country and the state of Michigan is based, at least in part. So to circle back and to support what Judge Burmeister has suggested, I leave it to this court's wise discretion and its experience to create some consequence that is of sufficient magnitude that this defendant, the next time he feels like he wants to resort to violence against public officials, public institutions, his neighbors, that he remembers what Your Honor did here and doesn't do it. Secondly, there are others who will hear about this. And to the extent that they think that they can attempt to affect a court or a legal process's decision based upon threats, veiled threats, it similarly degrades the integrity of our judicial system and our rule of law.
All right, thank you, sir. Mr. Grimurthy, allocution.
Thank you, Your Honor. Your Honor, Mr. Talbot is 37 years of age. When I review Mr. Talbot's prior criminal history, particularly the history that is here in the state of Michigan, he doesn't have any prior assaultive history at all. His history it deals with marijuana in Iosco County, and then in Ogama County and Crawford County, operating motor vehicle without insurance. So Mr. Talbot does not have any prior exposure of any sort to violence, or nor did I see from the AG's office any prior 404B motions indicating that Mr. Talbot was engaged in similar conduct or conduct that dealt with assaultive type behaviors. When I look at Mr. Talbot's treatment plan that we submitted to be attached to the pre-sentence report, when this incident first occurred, certainly when I was appointed to represent Mr. Talbot, I think the initial conversations were, and I think Mr. Talbot, recognized that this was behavior that shouldn't have occurred, and this is something that was out of character for him in the way he conducted himself. This was not something that he's done before. This was not something that he intends to continue acting and behaving in this manner, and certainly was something that he stepped out of line and out of his character in conducting himself with. He immediately enrolled himself with counseling, and it's important to understand his diagnosis of an adjustment disorder with mixed disturbance of emotions and conduct. It certainly resonates with what he was charged with and what he pled to. Since then, he has continued with his counseling, and the counselor indicates that Mr. Talbot does describe difficulty with regulating emotions. I think that's important to understand as well, that Mr. Talbot recognizes the downfall that he has with regulating his emotions, but the counselor also states that Mr. Talbot displays care and concern for the well-being of his child. And I think if Mr. Talbot continues with some treatment, then Mr. Talbot will have those tools and the availability of understanding how these coping skills, emotional regulation, and emotional awareness can be his strength, so he doesn't engage in similar behavior going forward. And when we look at his treatment plan, those are the identified concerns and client strengths: emotional awareness, emotional regulation, and coping skills. I think there was a break in his counseling due to some red tape bureaucracy where funding had stopped and Mr. Talbot couldn't attend counseling. Again, that's no fault of his own. And then I think that's reinstated or is going to be reinstated again with the funding that's available for Mr. Talbot to seek counseling. It's also important to know that during the proceedings with court, Mr. Talbot has complied with his conditions of bond, and Mr. Talbot has appeared at court, and Mr. Talbot has at least indicated to me his apology and sense of remorsefulness towards the two victims. And I practice before Referee Hill and Judge Burmeister often, and I've indicated to Mr. Talbot that the roles of judges sometimes puts them in a difficult spot. They don't like to make sentences sometimes, but that's the job and the role that they're in. They don't like to order people to do things, but that's the role and the job that they have. And once those orders are in effect and in place, it's the duty of the defendant or that litigant in front of that court to abide by those terms and orders and follow those. And I say that with Mr. Freza's comment that Mr. Talbot ignores court orders and doesn't follow court orders. And I don't think that is 100% accurate because Mr. Talbot has followed court orders here and has complied with the court orders and the pretrial release orders in this case. I believe Mr. Talbot would continue to follow those court orders. I did speak with Mr. Haven regarding the non-compliance during his pre-sentence report. Now, I want to highlight that non-compliance. I don't think Mr. Talbot was non-compliant. Mr. Talbot did not allow Mr. Haven to enter his house. And I didn't know this at the time that incident happened. I followed up with it after Mr. Haven indicated that to me. And Mr. Talbot said, well, if I'm told to follow a court order and there is no court order that a probation officer enter my house, do I have to let him in? And I think that was the recognition of court orders for Mr. Talbot with what orders he has to follow. And he indicated to me, once I'm on probation, I will comply with whatever those orders are. If the agent has to come to my house, he's certainly welcome to my house. If I have to meet him and report, I will certainly set a time, be there, and report there. But if I'm told that I'm essentially on this house arrest scenario where I'm not going to the courthouse, I'm staying away from the victims, I have this no contact order, and I have to appear for Zoom for all my court proceedings, I'm going to follow those. And that's what Mr. Talbot has done. As it relates to his sentence, the guidelines here are 0 to 9 months. I would agree with Judge Burmeister. And again, I go on the record with Judge Burmeister and argue against what Judge Burmeister usually orders. But I think in this instance, I have to agree with him that there has to be counseling ordered for Mr. Talbot because we have diagnoses now that identify some of the issues that this individual has. Adjustment disorder with mixed disturbance of emotions and conduct. And to simply not have oversight, not follow through with counseling, and not follow through with the coping skills that Mr. Talbot needs, I think the system then would do him a disservice without the oversight of making sure that Mr. Talbot is able to regulate his emotions and that Mr. Talbot doesn't engage in these behaviors in the future. I don't know what led Mr. Talbot to engage in the situation. I certainly did not see what the child support hearing was or what the conduct was by Mr. Talbot in that situation. My understanding is Mr. Talbot appeared for that proceeding by Zoom. So I don't know what really occurred, but I don't think that's the important part, but I think the important part is that after what happened and after he interacted with the police, he spent 4 days in jail. He was released from jail and then subsequently took steps to address what brought him before the court. And he didn't do that right before sentencing. He didn't do this, to get a better plea. He did this in the early onset and started this process early on so that, and this was way back in August, so that he could, I think it was even before August, but he may have done this in the first week of August to begin his treatment process. I'm not in the position to tell the court what an appropriate sentence is, whether by way of incarceration, but I think certainly an appropriate sentence for Mr. Talbot is to be on probation. The plea agreement that was negotiated with Mr. Freza's office also was a plea that was negotiated for the purpose of treatment, and that there be court-ordered counseling. So I think that is important for Mr. Talbot to have that court-ordered treatment process, so he follows through with it. Certainly, if he doesn't follow up with that, there's consequences. Certainly, if he doesn't sign the appropriate releases and submit those to Mr. Haven or whoever's agent is that is going to supervise him, there are consequences for that. And my understanding is Mr. Talbot intends to want to get treatment and follow through with treatment. So I would just leave that in the court's discretion as to what an appropriate sentence is regarding incarceration or otherwise. But certainly, we would ask that the court place Mr. Talbot on a probationary period with a primary focus on Mr. Talbot seek counseling and continue and complete counseling and have the appropriate releases signed for the Department of Corrections to monitor Mr. Talbot. But that's all I have, Judge.
All right, thank you, Mr. Gumurthy. Well, Mr. Talbot, I've reviewed this report. I've reviewed the additions that came from your counsel. I've listened to the prosecutor. I've listened to your attorney. I've certainly listened to the victims in this case. I haven't heard from you. I'd like to hear from you before I sentence you. What would you like me to know?
I'm sorry for all this. I never wanted to hurt anybody. I'm sorry.
All right, is there anything else?
I'm trying to continue with treatment. It's just some political money stuff that needs to get situated. I'm complying with all of the court orders that I have. I'm paying all my child support now. I'm an at-home dad trying to make things work.
All right, thank you, sir. Before me today for sentencing is Jonathan Samuel Talbot. He's a 37-year-old man. He's represented by his attorney, Mr. Gumurthy, who was appointed to represent him in this case. And he's before me because he pled guilty to attempted carrying a weapon with unlawful intent. That subjects him to a maximum sentence of 2 years, 6 months in prison. He does have credit for 4 days that he has served in county jail, and that'll be credited against any sentence that I impose in this case. There was an original count of carrying a weapon with unlawful intent in this case that is to be dismissed pursuant to the plea agreement of the parties, and it is formally dismissed at this time. If there's any good news in this event, it is that the defendant comes to us with a relatively minor record, meaning he's been generally compliant with the law up until this point. He has no prior felonies. He has 2 prior misdemeanors, which really bear no resemblance or, frankly, relevance to the current matter before us. There were some other matters that were charged and dismissed, but he has a marijuana conviction from years ago that may not even result in a conviction today. It's, as I said, a record that makes his actions in this case even more shocking and mysterious. The defendant was involved in a hearing related to his son. That hearing was being conducted in front of referee Hill. There was something that occurred at that meeting that ignited the defendant, as I understand the conduct of that hearing, he acted in a manner in the hearing that could have resulted in him being found in contempt. Well, contempt is a 93-day misdemeanor at max, with a fine of up to $500, I believe. Maybe it's more. Had that action taken place, perhaps he would have been in a better position than he is today, because he was not, based on, I think, the wise actions of the referee, he was not held in contempt at that point. The referee thought, as I understand her comments, that she would just let him frankly, simmer down, and leave the hearing. Again, I'm sure that's something that she's had to do before. People do sometimes get upset at hearings involving their children or involving custody matters in general, and referees and judges have to deal with that. We're used to that. Not every case results in a contempt finding. This one did not as well. But rather than process what occurred at the hearing the way a normal person would, this defendant instead went to his home, took out a machete, a very dangerous weapon, started walking towards town. And when he came into contact with the police officers, he indicated that he was heading to town and was making threats towards Judge Burmeister and Referee Hill. That is an extraordinary reaction, an unexpected reaction, a dangerous reaction to what may have been bad news at a hearing. But again, the reaction was not only unacceptable, it was illegal. It was clearly felonious activity. Number one, simply carrying a weapon and threatening someone is illegal activity. But to do so to a referee and a judge, who are the symbols, the living symbols of the justice system, is an attack on the system itself. And the defendant may or may not have realized what he was doing at the time, but the bottom line is he let his anger, his frustration with the hearing, take the best of him, and he took action, actual physical steps, to begin a process that could have resulted, had the police not intervened, in damage that couldn't be undone, and that would frankly result in a far more serious conversation than the one we're having today. So he is absolutely guilty of the crime with which he has been charged. The crime itself is, as I said, one that carries a maximum of 2 years, 6 months in prison. The guideline range here is 0 to 9 months. I think that guideline range is proportionate. I think it's consistent with the manner in which he presents himself and the seriousness of the case. This is as serious a case, frankly, for a first-time offender as I can recall seeing. It is an attack, as I said, not just on the individuals, but an attack on the system. And frankly, you could have been charged with a whole lot more than what you were ultimately charged with. You could have been charged with resisting and obstructing police officers. You could have possibly been charged with damage to a police vehicle. You could be looking at far, far more in terms of a potential sentence than you are here today, based on the discretion of the prosecutor. Had those kinds of charges been in this mix, or had you come to this court with some kind of felonious activity in the past, I can tell you without any hesitation, you'd be looking at a prison sentence today. I would not hesitate to send you to prison for this kind of activity. Do you understand that, sir?
Yes, sir.
But again, you don't have any substantial criminal record other than some relatively minor misdemeanors. You weren't charged with these other potential offenses. So we're dealing with the matter that is actually in front of us, which is, as I said, a 2 year, 6 month maximum felony sentence. I want to first acknowledge that I myself, in my work, and I've been doing this, I'm in my 9th year, have seen many people who are upset at the ruling that I make or colleagues of mine make. I've had death threats as well. I've had threats against my family as well. I've had to do many of the things that you heard from Judge Burmeister and Referee Hill in my own life, including protecting my family with a weapon, including notifying members of my family to be vigilant. And I know exactly where they're coming from. But I hope that you understand what your steps that they did to them and their family. You change things for them in a way that may never be changed back. You created an awareness really in their family and in their neighbors in the case of Referee Hill of the danger that being in these positions sometimes holds. And the fact that we have to deal with people who, like you, may have some mental health issues or other issues that result in potentially criminal behavior towards judicial officers. This kind of thing is unacceptable. This kind of behavior in and of itself certainly is unacceptable. But to put people through what you put them and their families through and their neighbors through in the case of Referee Hill is something that I hope you appreciate. It may have been a simple reaction to you, but it's a reaction that resulted in, I think, what Ms. Hill called ripples. It had rippling effects throughout the courthouse, throughout their families, even in their neighborhood. And again, that's something that you need to account for. As I said, this is an assault not only against individuals, an attack, if you will, on individuals, but it's also an attack on a system. And you also need to account for that. People need to understand that this kind of behavior is not tolerated, absolutely not tolerated, that it will result in serious consequences, that it will result in significant jail sanctions, or, as I said, if you had had any kind of record, even a prison sanction. In this case, I do, as I said, believe the guidelines are reflective of the seriousness of the case and the way you present yourself. I also agree that a probationary sentence is appropriate here, and I want to talk about that for a minute. I think it's very important that you get some additional counseling. It is clear to me, based on the information provided by your attorney and the statements that we've heard today, and frankly, your presentation here in court, and the substance of the offense that you've been convicted of, that you need some help. You need some professional help. I want you to be assessed by someone who is qualified to make a mental health assessment and to get appropriate treatment therefrom. I want the Department of Corrections to supervise that. So I am going to put you on probation for a period of 2 years. During that probationary period, the terms that have been proposed, number one, by the department in their recommendation will be ordered, as will the terms that normally apply to someone who is involved in an assaultive situation. That should include restriction from use of alcohol or any controlled substance. Should there be a need for modification of that in the future, I'd be willing to look at that. But for the time being, that will be part of your recommendation, part of your order of probation. As to a jail sentence, as I said, I can easily make a case for this to be a prison sentence, but I'm going to restrict myself to a sentence within the guidelines here. I do think there is justification based on the fact that you are attacking not only individuals here, but the system, to go towards the high end of the 0 to 9 months. The court sentences you to 8 months in county jail. Probation for 2 years under the terms that have been identified and discussed by the court. I'll leave the MDOC to prepare an appropriate probationary order for my review and approval. There are some fines and costs. There's a $68 state court cost, a crime victims assessment in the amount of $130, local court fees of $325, attorney fees in the amount of $350. There's a DNA testing fee of $60. There's an oversight fee as well that will be charged by the department for their monthly review or monthly oversight of your probation. That'll begin when you actually are released from jail. No other fines and costs. There were no claims for restitution. However, I would note that if there was a claim for counseling on the part of the victims, the court would order that as part of the restitution in this case. Are there any questions with regard to the sentence, Mr. Gumurthy?
Yes, Judge. So the pretrial release orders prohibited Mr. Talbot from appearing at the courthouse, and I think we've discussed that numerous times in the past. The jail, Crawford County Jail, is located right behind the courthouse. So if he's going to turn himself in there, today being Friday, I think if the court would give him a date and time of when to do so, whether it's 9 a.m. tomorrow or 8 p.m. this evening or whatever that is, it would eliminate the Judge Burmeister would be out of there. I see he's in the Crawford County Circuit Courtroom. I believe Ms. Hill might not be there. So I'm looking for some direction in that regard. As to the probationary term, Mr. Haven's office is also at that same building. I assume Mr. Haven is going to supervise Mr. Talbot, and judge at the Crawford County to check in with probation and parole. Mr. Talbot would have to enter the courthouse, not necessarily a courtroom, but a courthouse. The two courtrooms are located right when you come in through the court, through the security. There's a phone there on the left that he would have to call Mr. Haven and meet with him. But I describe all of those things because that puts Mr. Talbot physically in the building, and certainly Judge Burmeister and Referee Hill conduct court there. So I bring those things up again as to his reporting needs and necessities of how he reports, and if there's a way that the court would give some direction in how Mr. Talbot reports with Mr. Haven, or if this is going to be assigned to another county, which certainly then I would have a different argument regarding oversight fees and costs and otherwise.
All right, thank you, sir. Let me hear from Mr. Frezza before I comment.
I would just ask the court to consider adding additional conditions after he's released from jail with regard to probation. Those conditions would be no contact, direct or indirect, with Monty Burmeister and his family, and no contact, direct or indirect, with Teresa Hill and her family. We may add something about getting within some distance of them, if that is the court's consideration. I would also like the court to consider adding the condition that Mr. Talbot not possess any dangerous weapon. I didn't see that on the recommendation. That could be advisable given the offense.
All right, thank you. I'm in agreement with regard to all three of those matters. There will be a no contact provision during the period of probation, direct or indirect, or using social media with regard to Monty Burmeister, with regard to Referee Hill. Further, there is, and their families. Further, there is a requirement that will be instituted that the defendant not possess any dangerous weapon during the period of probation. He's a felon now, so he can't possess any guns anyway, but I certainly would include long knives or any other item that's unlawful.
And I've had other cases where defendants possessed crossbows when they had threatened judges. I don't know what sorts of dangerous weapons there could be, so anything that could be considered a dangerous weapon, I want the defendant to understand he may not possess.
All right. Thank you, Mr. Frezza. I think the defendant understands, and I agree with your comments regarding crossbow. Do you have any information regarding the matters that Mr. Grimurthy brought up, or should I go ahead and speak with the MDOC?
I would speak with the MDOC. I'm not familiar with the jail's procedures. All
right. We still have the MDOC with us. If you could help me out with regard to, and I know that you hadn't recommended probation, but I'm sure you've put some thought into how a probationary sentence would be undertaken. Could you give us some help with regard to where Mr. Talbot might be overseen, if that's going to involve the Crawford County Courthouse? If you could get me up to speed on your thoughts.
Well, Your Honor, he would report. Probationers normally do report to my office that is within the courthouse. I could make arrangements to report with him maybe on a separate day outside the courthouse, even if it's, downtown on the sidewalk. If the court wants him to be restricted from the courthouse, we can make arrangements to do so. Or maybe periodically even go out to his house. I do have to do home calls periodically anyway, but if he's gonna be restricted from the courthouse, we can make arrangements to meet otherwise.
All right. I do intend to restrict him from the courthouse for the time being. That's something that I would consider in the future as a modification. But for now, I'm still concerned enough about his mental state and the actual offense to require that restriction remain in place. So, Mr. Haven, I think what I'm looking for from you is what you've just given me, which is assurance that you will go ahead and proceed with his oversight in a manner that doesn't violate the order that he not come into contact with the Crawford County Courthouse. Is that correct?
Well, of course, Your Honor, we'll comply with the court's order. We'll prepare a probation order and get it to you for review. And if there's any changes that need to be made, we'll make those.
All right, I appreciate that. Mr. Gurmurthy, any other questions for the defense?
I would ask that you modify the language that no appearance or coming to the courthouse, extending that to courthouse and the courthouse parking lot. It's a fairly big parking lot, and I think that would, because it's on the other side of the railroad tracks, I think that would just be very clear that Mr. Talbot not be in the parking lot or on the side parking lot, and that would just minimize any. I want Mr. Talbot to be successful on probation. I want him to get this mental health assessment and follow those. So if I can be as clear as possible with him that minimizes any violations, I think that would benefit him.
All right, Mr. Haven, I think that makes sense as well. If you'd go ahead and include language to that effect in your proposed order. Anything else, Mr. Gurmurthy?
When would you like Mr. Talbot to turn himself in and in what manner, Judge?
We'll get into that in just a moment. We have a
Okay.
couple of other details we need to address. Mr. Frezza, anything else for the people?
No, Your Honor.
All right, the first thing I need to address with the defendant is that he has appellate rights. You do have the right to appeal this conviction and the sentence I've just imposed. You also have the right to the assistance of an attorney to prosecute any appeal you wish to take. But if you would like to appeal and you'd like to have an attorney appointed to represent you, you will need to sign a document to that effect, and we'll make sure that one gets to you. I'll have Mr. Haven hopefully make sure that that is directed to you while you're in jail. That document outlines your appellate rights, and it basically covers the things that I just discussed with you. If you wish to appeal and you'd like to have an attorney appointed, there's a line that you'll need to sign. You'll need to do that within the next 6 months and turn it into the jail or to the court or your attorney. If you fail to do so, your appeal will be waived. You understand, sir?
Yes, sir.
All right. In terms of turning yourself in, I'm going to need some help from Judge Burmeister. Maybe you can help me out. You may know more about the system in your county than certainly I do. Does the Crawford County Jail accept people in the evening, or do they prefer in the morning?
I believe they accept them in the evening. Certainly, I know they do accept them in the morning, but I don't think there's a problem with somebody coming in the evening.
All right. In that case, Mr. Talbot, I'm directing you to turn yourself into the Crawford County Jail by 7 o'clock tonight. If you fail to do so, there will be a warrant out for your arrest, and that warrant will be executed. Do you understand, sir?
Can I please have some more time?
You are expected to be at the Crawford County Jail by 7 o'clock tonight. Do you understand, sir?
Yes, sir.
All right. All right. Is there anything else that we need to address for the people, Mr. Frezza?
Not from the people, Your Honor.
For the defense?
Can I ask?
No, Your Honor, just for the record, I will get Mr. Talbot his appellate paperwork while he's in jail. So perhaps next week and have him acknowledge receipt of the appellate paperwork.
All right. Thank you, Mr. Gurmurthy. All right, Mr. Talbot, good luck to you. And to the victims, once again, we're sorry that this happened to you. Take care, everyone.
Judge, just a housekeeping moment, a minute before we go to break. On that, yes, Mr. Gurmurthy is going to have those appellate rights to address with his client. More importantly, I am going to be emailing you the judgment of sentence, because the jail typically likes to have those before they report in. So are you gonna be able to get that signed today?
I am now, absolutely. We'll
Okay.
make sure it's
Okay,
taken care of.
great.
We'll get it back to you. You bet.
Okay, give me just a moment to get that scanned in and emailed off. Thank you very much.
All right.
And-
Take care,
And
everyone.
Madam Clerk, if, as long as you're sending an email, would you send a copy of the judgment of sentence and any probationary order to freza.m@michigan.gov? That's my email. It's also in the bar journal.
I can, that probably will be done on Monday because I don't know when Mr. Haven's gonna meet with him to have the probation order signed, but I can send the JOS as soon as I'm able to.
Thank you.
All right. Thanks, everyone. Take care.
Okay. What is your question?
But,
What?
but